Hi everyone, I'm Sabrina, one of the lawyers at Verity Law. Recently, me and my legal team drafted many different types of shareholder agreements for our clients. This agreement is crucial when you have more than one shareholder within your company, as it can avoid costly litigation and stalemate in business operations later on. Also today, I have the pleasure of having Mr. Ruzben Husseini join us. Ruzben is an experienced litigation lawyer and a partner at the law firm Cambridge LLP. What I find refreshing about him is that often he encourages out-of-court settlement and arbitration for his clients to save them money and time while still getting them many elements of their desired results.
Thank you, Sabrina. My name is Ruzben Husseini, and I am a litigation lawyer. I'm a partner with Cambridge LLP. We are a firm of 30 lawyers, and we have full-time offices in Burlington, Toronto, Barrie, and Elliott Lake. We focus on resolving disputes that businesses may have. To highlight what we do, we work to resolve disputes related to collections, construction litigation, breach of contract cases, internal business disputes, mortgage matters, commercial lease disputes, and other litigation matters that may arise.
Okay, let's dive into today's topic. First, a shareholder agreement, in combination with the corporate minute book, should clearly list who are the current shareholders. This information is often not found on your government-registered articles of incorporation. Many clients ask me, okay, then what about future shareholders? Well, we always include a clause in the agreement that say any future shareholders who choose to subscribe to shares will be given a chance to review the shareholder agreement. If they do not object to the agreement within a certain number of days, then it's considered they agree to it without having to sign it.
That's a really good point. That's why before you decide to purchase shares and join a corporation, you should always check with the existing shareholders to see if there is already a shareholder agreement in place. When you receive your share certificates, the certificate should include a phrase stating that by agreeing to purchase the shares, you agree to the existing shareholder agreement.
That's right. And how decisions are made within a company is very important and should be specified in the agreement. Directors are the ones who make most day-to-day decisions, like deposits and withdrawals into the business bank account. In contrast, shareholders, who are the owners of the corporation, make decisions relevant to the shares themselves. For example, what are the share classes? A common example is some shareholders hold voting shares, meaning they can choose who are the directors, while other shareholders hold preferred shares, meaning they can only invest into the company and receive dividend returns. They cannot make any decisions regarding how the company operates.
How much a dividend each shareholder would receive and when to start making those payments can often be disputed. The issue typically arises when one shareholder insists on drawing a dividend while the other wishes to reinvest the profits in the company. These types of disputes can lead to a breakdown of the business relationship, which ultimately may lead to a windup of the company if the dispute cannot be resolved. It is essential that the issue of how much of a dividend is to be issued and when be agreed to at the outset.
That's right. The shareholder agreement should clearly state how much percentage of shares is considered a majority. Only when a majority of shareholders agree on an issue can their decision be passed. For example, let's say the agreement and minute book set the shareholder majority to 75%, and the company has 4 voting shareholders, each holding 25% of the shares issued. This means that at least 3 out of the 4 shareholders must agree on an issue for that decision to be passed. If the company has any preferred shareholders, they do not participate in decision making.
That's right. Although sometimes minority shareholders still have rights that can be protected under the law. Those rights protect minority shareholders from oppressive or unfairly prejudicial conduct by the corporation, its directors, or other shareholders. The unfair prejudicial conduct can exist in many forms. For example, we successfully protected minority rights where the majority shareholder took steps to lock out the minority shareholder and take 100% control of the business.
Now, shareholders usually do not have any obligations to put money into the corporation unless it's specifically required in the shareholder agreement. There are 2 ways in which shareholders can invest into the corporation. First, they can simply buy more shares. The price per share should be routinely determined and updated by the directors of the corporation and agreed to by a majority of directors and shareholders during their meetings. It's important to understand that unless otherwise stated in the agreement, any shareholder investment into the corporation is not protected. Meaning, if the corporation loses the money, then the shareholders lose their investment. Second, the shareholders can make loans into the company and become creditors. But again, if the loans are not secured by collaterals like real estate, the shareholders may be unable to recover their loans if the corporation performs poorly.
Yes, although there are situations where the shareholders can sue the directors for not managing the corporation well and losing their money. This is typically seen where a director is favoring himself or herself over the company. This can happen when a director takes money or other assets or clients from the company. It could also occur where the director takes a corporate opportunity from that company.
Yeah. And next, a big issue is whether the existing shareholders may sell their shares to anyone they want. If they can, then the shareholders who remain in the corporation will have to run it with a stranger. For example, let's say Amy and Sam started a company together and they're both voting shareholders. Amy decided to sell her shares all to George without Sam's agreement. Now, Sam have to run the company with George, who is a stranger to him. To prevent this, it's essential to have share transfer restrictions in the minute book and in the shareholder agreement that will prevent Amy from doing this.
Of course, the corporation can't just be in a stalemate. So if there are share transfer restrictions, the agreement must clearly say what happens if Amy wants to sell her shares, but Sam does not agree.
Exactly. A common solution is requiring any selling shareholders to offer their shares to the existing shareholders first. This means Amy will need to make an offer to Sam to sell her shares before she can offer it to outside strangers. The opposite can also be done. The shareholder agreement can include a shotgun clause where Amy can offer to buy all the shares held by Sam. This way, she can have the company all to herself.
Yes, both of those solutions are good for when the shareholders can no longer get along. But sometimes buying each other out may not be an option. Perhaps there are just way too many disagreements, for example, on share pricing. Using the same example, Amy may want to sell her shares high, whereas Sam wants to buy the shares at a much lower price. In those cases, it's important to rely on dispute resolution clauses in the agreement.
Of course, and this is where your expertise really shines, Rusbin. Other than litigation, what are some other types of dispute resolution that you recommend?
Almost in every instance, I recommend that business disputes be resolved by arbitration instead of litigation. Where the dispute is not as serious, I recommend the parties mediate. If the parties agree, they can commence a process called medarb, where the arbitrator first attempts to mediate a resolution and, if unsuccessful, will then arbitrate the dispute so that it can be resolved.
And how do those methods compare to traditional litigation?
Arbitration is a method of resolving disputes outside of the courts. It's a process where conflicting parties agree to submit their disagreements to a person or people who will make a final and binding decision on the matter. This approach is often chosen for its efficiency and confidentiality. Mediation is a structured negotiation process where an impartial third party, the mediator, assists the disputing parties to find a mutually acceptable solution to their conflict. Mediations are also confidential. The difference between arbitration and mediation is that a mediator does not have authority to make a final decision that binds the parties. Medarb is a combination of both mediation and arbitration and is conducted by the same person. The mediator will assist the parties to attempt to settle and will subsequently act as an arbitrator if settlement fails. The benefit of medarb is that the same person is retained to act as a mediator and later as an arbitrator. And that person is going to be familiar with the dispute and would have a more efficient way of making a decision in comparison to a situation where the mediator and arbitrator are different people.
All right. Next, let's quickly touch upon non-compete and non-solicitation clauses. Often, when a shareholder leaves a company, the other shareholders remaining in the corporation do not want to see that person start shop elsewhere and become their new competitor. To that effect, they can include a non-compete clause in the agreement.
You can do that, but you have to be careful. This clause cannot be drafted too restrictively. There are many instances where the courts have ruled that non-compete clauses are not enforceable. It is essential that legal advice is obtained in advance.
Exactly. This clause should be limited in time, distance, and business type. For example, if Amy and Sam's companies specialize in selling coffee, then a reasonable non-compete clause could be when Amy leaves the corporation, she cannot start a coffee shop within 10 kilometers of the owe the corporation for the next 5 years. In contrast, an overly restrictive non-compete clause could say Amy cannot start any type of food and beverage related business within Ontario for the next 20 years.
Yes, if this matter does go to court, judges do not like to enforce overly restrictive non-competition clauses. This is because the law favors competition, and non-competition clauses act as a prohibition to competition. While there may be good reasons in certain circumstances for enforcing non-competition clauses, courts will scrutinize such clauses carefully, especially where a person's livelihood is at stake.
Yeah. Similarly, we can put in a non-solicitation clause in the shareholder agreement, which will prevent Amy from approaching the corporation's existing employees and clients in an attempt to take them with her. But do be careful here. Employees and clients have their own free will, and they're not simply commodities owned by the corporation. If they decide to leave with Amy out of their own free will without her having approached them, then the non-solicitation clause may not apply.
That's right. The important word here is solicitation. While Amy may be prohibited from contacting employees or clients, it does not mean that those same employees and clients are prohibited from contacting Amy. So if Amy leaves and the clients contact Amy to follow her, the clients are free to do so. Business owners sometimes misunderstand that the prohibition on solicitation is a one-way street. Non-solicitation clauses also don't apply if they are unreasonable. For example, I have seen cases where non-solicitation clauses were attempted to be enforced against a receptionist, as an example. This would be unreasonable because it would be deemed to be too restrictive.
Oh, that makes sense. Lastly, shareholders may want to include a confidentiality or IP protection clause in the agreement if their business deal with private proprietary materials. The key here is to clearly identify what is considered confidential. Having a general clause saying everything not normally revealed to the public is confidential may not be helpful. Ideally, in addition to this clause, the company should clearly list everything that is confidential so no one leaks those information unintentionally.
For sure. Often shareholders and employees don't want to breach confidentiality, but they didn't know those things were meant to be kept secret in the first place. The problem is, once a secret is out, there is really no perfect way of fixing it. We can apply for an injunction with the court to stop the breaching party from continuously revealing the secrets to the public, but once a secret is out there, it's out there, and it's no longer a secret. The best way is to prevent this from happening in the first place.
Exactly. All right, that's all for today. Thank you, Ruthven, for joining us. Now, before we go, I'd like to make an announcement. I am pregnant with our second and final child, and my due date is July 19th of this year. My staff, John, Jaden, and Suki, will be working full-time while I take a 1-month mat leave, just like I did with our first child. So I will see all of our viewers in 2 to 3 months' time for our next video.